All right, just one or two more subjects. This subject's going to be me talking about the initial response rule under Rule 12. All right, Rule 12 tells the defendant or a defending party that they have to give a response to a pleading containing a claim, either by answer or by pre-answer motion. All right. A number of defenses are listed in Rule 12b that can be raised either by complaint or by pre-answer motion. These defenses are listed numbers 1 through 7. You should be well familiar with all of them. We're going to categorize them here, and I'm going to do them using the terminology I got from Professor Glannon. Numbers 2 through 5 are disfavored defenses. Number 6 and 7 are favored. And number 1 is most favored. Let me take them in reversed order. The defense of lack of subject matter jurisdiction can be raised at any time by the parties or even by the court, all the way during the case, through trial, and through appeal. Because subject matter jurisdiction is not waivable, it's so important, the court has an obligation to question its own subject matter jurisdiction if that SMJ appears to be lacking. Initial response rule is not concerned with number 1. The favored defenses are those of failure to state a claim upon which relief can be granted, which of course concerns Iqbal, doesn't it? Iqbal and Twombly. And the defense of failure to join a party under Rule 19. Okay? That's the defense of trying to dismiss a civil action for failure to join a necessary and indispensable party. You know, a Rule 19 required party. Well, these defenses can be asserted in the answer, in a motion. They can be raised all the way through trial. All right? These are not subject to the initial response rule. These last defenses, numbers 2 through 5, are subject to the initial response rule, which is a use them or lose them kind of rule. You assert them early and in the right way, or they are waived and they are gone forever. Now the reason for this is, first of all, these are all non-merits defenses. They're procedural defenses that don't hinge upon whether or not somebody states a claim, whether somebody's liable or not liable. They are purely procedural defenses, and additionally, they're defenses that normally ought to be discernible by a defending party immediately by reading the face of the complaint. Now here, of course, we're talking about the reasonable litigant, right? If you sue somebody and they read the complaint and they don't know what it means, they don't hire a lawyer, they may not have actual knowledge that they have one of these defenses. We're instead asking whether a reasonable litigant would know they have the defense, right? That's the idea. These defenses ought to be easily discernible by reading the complaint. And because they normally are, they're going to be lost if they're not asserted early and properly. You know, if the defendant can't read the complaint and doesn't know how to defend, then maybe they should seek a motion for a more definite statement. But assuming the complaint is sufficiently clear, these things here are likely to be lost if not asserted properly. Well, how do you assert a lack of PJ, lack of venue, lack of proper process, or service of process? Well, you can do it either through your answer or through a motion that is served prior to serving the answer. In other words, a pre-answer motion. The gist of the initial response rule is that, subject to some qualifications that I'll note momentarily, that you must assert any of these defenses in your initial response, regardless of whether that initial response is a pre-answer motion or an answer. Doesn't matter, generally speaking. If your initial response is a pre-answer motion, use it or lose it. If your initial response is an answer, use it or lose it. By use it or lose it, I mean assert it, right? Raise it or lose it forever. Now there's a couple of important qualifications to that. First, under G2, the waiver rules don't apply if the disfavored defense was not available to the defendant at the time they serve their response. Okay? That usually doesn't come up, but sometimes you have a pleading and there's no defense, and then there's an amended pleading, and now for the first time, one of these Rule 12b defenses might arise. Think, for example, P from Pittsburgh versus D from Miami, D from Tallahassee, all right? And the suit is brought in the Southern District of Florida. You with me? Well, assuming there's PJ, assuming the process is fine, well, I don't see any problems here, right? PJ, venue would be okay in the Southern District of Florida. There's no problem. There's no need to raise venue as a defense. But what if the plaintiff does an amended complaint that adds somebody from Anchorage? See the problem here now? We now might have a problem with venue, because if the only basis for venue is 1391b1, now all of the defendants don't reside in the same state, and for the very first time, venue might be attackable for a lack of venue. Well, you go back to the rule, the initial response rule doesn't apply if the objection was not available to the pleader at the time they made their initial response. Okay? That's one exception to the initial response rule. Here's another one, which is this language right here. It's sneaky. And that deals with the following scenario. The initial response was an answer, not a motion, but an answer. And that answer is amended quickly as a matter of course. Let me illustrate with a hypothetical. P sues D. D's initial response is an answer. Asserts no PJ. Suppose, plus 10 days later, the defendant does an amended answer saying no PJ and no venue. Now you'd think the venue would be waived, right? Let's assume that the venue objection could have been raised in the earlier pleading, but it was not. Well, in an application of the initial response rule, venue's gone, it's waived forever. But when was the amendment done? 10 days after the service of the original answer, right? How long does the defendant have to amend their answer as a matter of right, in terms of the rule, as a matter of course? 21 days. This is not just any old amendment. This is your one-time mulligan, your one-time do-over. Your opportunity one time to make an amendment as a matter of course, without consent of the other side and without having to make a motion of the court. Now let's go back to the rule. An amendment as a matter of course under Rule 15a1 rescues the omitted disfavored defense. Isn't that neat? Now if that's on the bar exam, you're going to get it, and most people won't. Most people will see this fact scenario and they will conclude that venue is waived. It is not. Pretty neat. All right, so that's the initial response rule. I'm going to stop this video and move on to another topic. Thank you.